Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, what is it like? Understanding the views and perspectives of a plaintiff's lawyer. In many cases, our bar association tends to be more defense-oriented, although we have been getting more and more members of the plaintiff's bar. Today, we have a very special treat. We have a prominent plaintiff's lawyer who's been around for some time, who's going to talk to us about how he views things like the state of class actions, how to bring them, what might change in the administration, and just as importantly, how to build a practice and understand how to be a successful plaintiff's lawyer. My co-host today is Anora Wang. Hi, Anora.
Hi, John.
Nora, what are we doing today?
We are actually doing two things. First, we're going to talk a little bit about a class action and the possible changes in Congress and agencies. And then we're also going to try to learn the perspectives and principles of how a class action plaintiff-side lawyer works.
Who's our guest?
Our guest, Danny Karon, is a perfect guest for doing the two things together because he's a class action attorney at Karon LLC, and he chairs the ABA's National Institute on Class Actions. He used to teach complex litigation at Columbia Law School and now teaches consumer class actions and complex litigation at the University of Michigan Law School. Daniel is very well published, and he also has his own website, which you can check out. It's called yourlovablelawyer.com, and where he promotes legal wellness and consumers' legal rights.
All right, well, let's bring him in. Danny Karon, welcome to the program.
Hey, guys. It is a thrill to be with you. Thanks for having me.
It's our pleasure to have you, Danny. So as we have already briefly discussed, we're going to construct our conversation today in roughly three buckets. So we're going to first just enlighten our audience a little bit about class action. To start off, perhaps go to the very core question, why is class action important for consumers especially?
Well, it's funny you added especially at the end, too, because that changes my answer. Makes it a little more thoughtful. And it was thoughtful to begin with, by the way. They're important because often problems that folks have involve damages too small to do anything about them individually. I mean, you're not going to go to court. You're not going to have jurisdiction to go to a decent court. You're not going to go to small claims court because of the time involved for a $50, $500 even claim, sometimes even $1,000 claim. It's kind of a tweener. It's in between there where it's just not big enough to do anything about, and no lawyer's going to help you with it. So you're kind of on your own, and we know what happens then. So class actions keep not only help folks recover what they're owed when they're damaged small amounts at a time, but they also keep businesses honest. They keep them from cheating people in small amounts at a time because companies understand that it's not okay. Now, what I mentioned a second ago about the provocative end to your question has to do with this. Class actions aren't just good for consumers. They're good for well-behaving companies who, without the presence of class actions, are going to lose market share and sales and profits to unpoliced cheaters who are going to run rampant through the marketplace and do things the wrong way, the way that well-behaving, responsible companies don't. They do it in a way that doesn't get them sued because they don't want to cheat people. They want to put good product in people's lives to make people's lives better. And I first came to appreciate that perspective when I started doing class action defense work. So I do both sides. And I think it's essential to do both sides, to understand the motivations and stakes involved on both sides of the V. Now, I used to think that victims were only on the left side of the V. Mm-hmm. I don't think that way anymore. There are a lot of victims on the right side of the V because there are a lot of bad class actions out there. So together, we have to work to sue responsible cases that make the world a better place, that help consumers who need it, and protect companies who deserve it. The cheaters are our shared target. That's who class actions ought to focus on.
I'm glad you brought that up. So you, quote unquote, you said there are bad class action out there. Perhaps sometimes they are frivolous, or sometimes they're not they don't have sufficient merits. But how do we know the current level is the optimal level? And how do we know that currently it's under-enforced and then there should be more class actions?
I don't know if it's a function of level. I mean, the proper level, I think, tracks the number of cases that deserve being sued. I thought where you were going to go was how do you know a bad class action? And kind of a bad class action is kind of like obscenity. I mean, you know them when you see them. You look at Subway footlong. You look at Starbucks iced coffee. You look at a lot of slack fill cases. Did you realize that Captain Crunch with Crunch Berries aren't real berries? Well, a claims have thought they were, and they made a federal case out of it, federal class action. These are the cases that the Chamber of Commerce tees off on when they want to make an example of class action lawyers for having sued stupid cases. And that ruins the good ones. And that goes back to my thesis at the beginning about how, bad cases ruin it for the good ones and for well-behaving companies. But in terms of level of enforcement, how many are enough? When the good cases that deserve to get sued and deserve resolution in the right way rather than being poured out on emotion because of unduly strict laws, when that happens, kind of like, Justice Ginsburg once said at the Supreme Court, when will there be enough women? When there are 9 of them. Kind of like there'll be enough good cases out there when the good ones are in suit and have a fighting chance.
That's a very thoughtful answer. But then what are some obstacles that's, talking legally, that's preventing consumers come together with thoughtful counsels to bring such good quality or just, with merit class actions?
Well, I don't think there are many obstacles to bringing them. I think there are a lot of obstacles to winning them. And if you bring a bad one, you're going to find out about those obstacles a lot sooner than if you bring a good one. Now, if you're talking legally speaking, what pours out most class actions? Well, you've got to take a look at Rule 23 and the elements that you need to demonstrate to the court's satisfaction before the judge will flip the switch from an individual case to a class action case where you got leverage. Because when it's just me against whomever, they don't care about me. When it's me and a million of my friends, they take a second look. So what causes problems for plaintiffs in class actions? Well, it ain't numerosity. If you don't have enough folks, then you're in the wrong business. Don't even sue a class action case. Go, do divorce work, do tax law. Don't do class actions if you're not going to be able to satisfy the numerosity requirement. And it's really not typicality and commonality and, adequacy. It's really about predominance as it concerns money damages. And I know we all listening to this know what I'm talking about. That is where 99% of consumer cases go to die. When you can't sufficiently demonstrate predominance in such manner as to hold the class together and give you what you need to encourage certification. And, consumer cases are such one-offs that they lend themselves to predominance problems. You take a look at an antitrust case, it's always about impact. You look at a securities case, it's always about, I'm not so sure because I don't do securities, but it's not as tough as consumer probably. But consumer's tough. And that's why and where, textually speaking, the toughness occurs.
I'm glad you brought up numerosity and predominance as the 2 most important things that we're talking about here. And we can come back to numerosity. I think that goes to awareness. And then how do you actually gather a group of consumers and then to essentially to be ready to have a good enough class action. And then, but for now, let's talk about some other obstacles. Financially, if I only expect to have $50 in return as, compensation to my damages, I'm not that motivated to actually spend a lot of time or spend anything out of pocket, right? And how is that resolved in the current scenario?
I think that inquiry goes more to incentive than it does to, it goes to the client's incentive. As opposed to the lawyer's incentive. And plaintiffs' lawyers being incentivized is hardly anything new, and it's hardly a dirty word. I think it was in AmChem that Justice Ginsburg again talked about, class actions involve damages so small that it's usually not worth it to somebody other than a lawyer, to pursue. She put it more eloquently than I did, of course. But if you're wondering about, why would somebody want to be a class representative when the stakes are so low, that kind of begs the question, are the stakes really that low? How do you measure stakes? If there's not a lot of money at stake for yourself, they're low. there's a lot of money for a lot of folks who also deserve it. Say it's a toxic dumping case. Say it's a civil rights case. Say it's something that really makes a difference and matters, and somebody wants to take a stand and make a difference. Then, you can recast the stakes analysis. If you're wondering about stakes for the lawyers and whether they're sufficient to justify the expense involved, because expense, comes in a couple of shades, comes out in out of pocket, and it comes in opportunity cost. It comes in selling it to your partners that you're taking a gamble with their money,
right?
And which is why I don't have partners anymore, because it's a pain in the neck, and those sorts of things. I was involved in one antitrust case where our eventual expenses were $6 million, and you don't know if you're going to win. I knew defense counsel was winning every month when they invoiced their clients. I mean, those folks, get paid per hour. I'm getting paid perhaps. And that's a scary, you can laugh at that. That's a scary construct to pin your practice on, which is one of the reasons I do defense work too, because I like getting paid. No shame or harm in that. But you don't know if you're going to get paid. You don't know who's going to show up and challenge your fee. You don't know who's going to object. You don't know whether your judge is going to die and somebody else is going to slot in who's going to pour your case out. You don't know whether the Supreme Court's going to flip. You don't know whether the law is going to change. You don't know whether, and I mean, I had a case where the courts, it was looking great until the court's law clerk switched out and a new guy came in and he wrote the opinions and poured us out. I mean, I was looking toward retirement on that case. If I had a nickel for every one of those, I wouldn't be doing this. I probably would because it's a lot of fun. But it's fraught with peril, the plaintiff's game, which is why if you take a look at what John Grisham writes and what Hollywood produces, respectfully speaking, and I really mean this, they are not putting out movies and books about the defense world. There are no stakes and romanticism and excitement and intrigue and fear. There is, but a different way, as there is on the plaintiff's side. And you got to have, a brass, or what's the example? You've got to have real temperament. We'll just go with that.
I do have to say, as a defense lawyer, and John probably would agree with me, I don't know I'm not sure how to react to the contrast you draw between plaintiff's lawyer and it sounds like we're living in heaven. We're paid per hour and then it's great. No, listen, and I'll tell you, I'll argue the other side. I do not mean to suggest that. I wrote an essay not long ago on plaintiffs and defense lawyers, how we really need to just to get along, respect each other's model, each other's goals, each other's values, how we're representing folks because we believe in our charge. And I got an inside look, and having done defense work, I'll add, I've gotten an inside look. It is not as simple as, hey, flip on the meter and just go to town. Last defense gig I had a budget. Last I looked, I was 10,000 over, but I needed it to do the job, and I ate half my time. And it is not as easy for you as I would suggest either, but it's different. Let's go with that. Yep.
I think the Hollywood movies are made about the quarterbacks and the wide receivers and not the middle linebackers and the cornerbacks. That may be part of it as well. But Dan, you hit on I think a really good point, which is the models are fundamentally different. And on the plaintiff side, I think at the beginning you have to make a very early assessment, and forgive this term, about whether the investment is really worth it.
Yeah, there's no need for forgiveness. It's a business, and that is okay. I used to get all worked up when talk would turn to money, investment, that sort of thing. It's okay.
Well,
it really is.
And then what you have to consider, I think, also is there are some people that have principles. And sometimes those principles, people say the investment is worth it because of these principles. Sometimes that doesn't exist, but sometimes it really does. And I think on the defense side, it's very rare that we'll take a case on for a corporate and say, I'm ready to do this for free. Sometimes, but it's very rare.
Mm-hmm. Right. And a lot of my stuff works out to be for free. Speaking of principles, I'll tell you what I was working on earlier today is it's an individual case. It's a really grisly sex abuse case that derives from that Ohio State sex abuse case involving that doctor and the wrestlers. That's my case. And I got on this guy's radar down in Columbus whose children were abused by his father. And he didn't know it. Otherwise, he would have stopped it. But it turns out that the father's brothers and sisters, my guy's aunts and uncles, knew that Grandpa was a molester. They'd known for years, and they knew that he was babysitting the young girls. And they chose to say nothing because it was just harder that way, more uncomfortable, more difficult. And all of it could have been avoided. And we have caps in Ohio, and I'm not going to make a ton on this case, but I'm not doing it for the money. Because one of the reasons I quit my last firm, I said to one of my former partners, I said, I was going through one of these existential angst-ridden moments about why we do what we do and push that boulder up the hill. And I said, you know what, if you want to just make money, you can do pretty much near anything. But if you want to make a difference, you become a lawyer. And he said, I don't know what you're talking about. And that's when shortly afterward I said I quit. And I did, my own firm. And I'm doing that case because it matters. And it's killing me. And it's okay. Because that's what we're here to do, is to solve people's problems.
Yeah, well said. Coming back to, I was going to include in my first bucket of discussion covering states law, but maybe let's come back to that later. Let's go to legislative and agency moves just on a federal level. What are we, if you're holding a crystal ball in front of you, what are we expecting to see? Are there any efforts being made right now in Congress?
Well, I know we're not on video, but I do have my magic 8-ball. And let's see what it says. Without a doubt. Go figure. Look at that. And I would agree with my magic 8-ball because the CFPB is instantly a lot more robust than it was under Mulvaney and I always forget it, and Kraninger. Rich Cordray, who did a great, he's an Ohio guy, he's a buddy of mine. He really went to town. Pulling in over $12 billion in restitution in his first 5 years to Mulvaney and Kraninger's paltry $800 million in the, I think it was past 3 years. So he was doing the job. And I think the CFPB's new director, so much for my fluidity. Hang on. Rohit Chopra out of the FTC.
Yeah.
Did I get that right?
Yeah, that's right. We know him. We know his work pretty well here in the antitrust law section.
Yeah, it keeps you busy. And, it's going to be a different culture. It is. And with more robust, enthusiastic, and purposeful enforcement, it's going to spawn plaintiffs' cases. It just, one follows from the other. Or what the cases follow from the enforcement. But if you're thinking, legislative changes, well, the House just reintroduced through Representative Henry Johnson out of Georgia, I'm going to screw this up, the Forced Arbitration Injustice Repeal Act. I think I got it right. That blew through the House last session and stalled in the Senate. Well, I suspect it's going to get through the House again. And if it does, Senator Blumenthal just introduced the Senate's version of that. So whether, it makes it through both houses and gets signed by Biden, it would really tamp down on forced arbitration and consumer contracts, which is often where these cases go to die. Never mind class cert, you don't get out of the pleadings. And that's obviously a result of the Concepcion case from the Supreme Court a number of years ago. So those are a few changes I think we can hope for.
Right.
Depending what side you're on, that is.
No, that's fine. I think forced arbitration as an issue that you have raised is probably going to see some changes there. But also, other than personnel changes, there are some, of course, that come hand in hand, priorities of their enforcement. I think in one of your recent articles that's published in Law 360, which we're going to put a link on the website, you talked about agency is going to target individuals rather than corporations a little more. Is that right?
Well, that's what I said because that's what I read. What'll happen, here comes a crystal ball. I don't have the same insight into that as I do as it concerns the CFPB and the FAIR Acts because I'm seeing what's happening at the CFPB and I'm seeing what's happening in the House and Senate. Whether that will evolve as a matter of antitrust change, I don't know. What I tend to focus on as it concerns antitrust is, horizontal price fixing cases. And interestingly, but refreshingly, that's always been a bipartisan issue. Nobody supports criminals, felony price fixers. And, even the beef industry was in the crosshairs during the Trump administration when the Department of Agriculture, when Sonny Perdue testified as to the potential for price fixing and gouging as the result of COVID. And DOJ civil side is on top of and all over DOJ, of the beef industry, just as they are the broiler industry and some others. Broilers are broiler chickens.
Mm-hmm. And another thing that comes along with the changes to personnel in agency is that perhaps the approach to certain changes is not always going to be through legislation. For instance, CFPB might be able to push out some more regulation with regard to overdrafts, debtor-creditor communications. I think
payday loans. Payday loans. Yeah. That was a big one that went nowhere when Pence broke the tie in favor of not reforming the payday loan laws. That might happen, or regulations, I should say. That might happen. The Consumer Product Safety Commission, I understand, is going through some changes, as you'd expect, with new, I have to believe, directorship. And how that's going to evolve, I'm not sure, but with more aggressive enforcement, that might spawn product cases, and product cases that lend themselves to class actions to the extent it's a uniform defect, manufacturing defect, or design defect cases. It could happen too.
That's great. And perhaps this is a good time to turn to state laws, other than federal changes that we're predicting, and we don't know if we're right or wrong in a few years. But state laws, are there anywhere, I guess, in terms of consumer protection, are there any things that's more advantageous if you bring them under state laws? Perhaps privacy, perhaps data?
Well, Illinois got a really aggressive biometric statute. People are, really enthusiastic about that as it concerns privacy and privacy violations. Otherwise, it depends on the state. I'm in Ohio, and the Consumer Sales Practices Act has a lot of extra scales on it, and it's not very. There's not a lot of vitality to it. So I wouldn't think to jump into a consumer fraud case in Ohio like I would in California or somewhere that's got more forgiving laws. So if you want to consider, maybe state enforcers like attorneys general, when the CFPB was dormant, the state attorneys general had to jump in to fill the breach. I actually published an essay on that some time ago about how state AGs were doing the job that the CFPB let the country down on. And I wonder whether, what effect a more active CFPB will have on or having the need for state AGs enforcement, or whether they'll work in concert, which is probably what will happen. Because aggressive states AGs, I can't see them standing down in favor of the CFPB. They've got state issues and problems to solve. It just might be more collaborative now.
I think it'll also be, as we watch the states and the state AGs, I think another issue just to keep an eye on. As we record this program, we don't have a decision yet in the FTC's case around its ability to get restitution, 13B. One of the things I think that folks in the antitrust community have been talking about is in a world where the FTC no longer has disgorgement authority, the state AGs play a very important role. Because effectively, they would be the folks that would step in, going along, right, arm in arm with the FTC, and they would, a number of the state AGs would have the power to seek that sort of restitution damage.
And you know who that pinches? That pinches the private plaintiffs' lawyers, because the private plaintiffs' lawyers want to be able to go after restitution like they do in Section 1 cases, where DOJ is just looking for a conviction, and FTC, where they've gotten restitution, or state AGs where they've gotten restitution. I'm thinking of, for instance, the LCD price fixing case, where lots of AGs jumped in. And I believe CRT as well, cathode ray tubes. And now you've got some conflict between the private lawyers and the state lawyers in terms of who's responsible for all this money that goes to effectively the same bunch of people. Whether in a parent's capacity or individual capacity, come on, let's be honest. People in the state are people in the state. And it's not like the AGs can take a fee. The plaintiff's lawyer can take the fee. They'll take their 28, 30, 33 to 30%. And that can be contentious. That's another issue the defense lawyers don't have to worry about.
In a world where the FTC doesn't have that authority, then do you see private plaintiffs wanting to play a more prominent role?
Oh yeah. I had several FTC cases against the real estate industry where the FTC entered into consent decrees with various markets, MLS, multi-listing services, against involving kind of old guard, standard, long-standing realtors who'd always been there, and they didn't like the innovator realtors showing up and offering these more innovative, online-based business models where they take a lower commission for doing, kind of a menu of services, whatever you wanted. So the old guard, they were put off by that because if you're showing up on the buy side of a transaction that should have paid 7%, but now it's only 3% because of the innovator broker on the sell side, you're taking half of a lower amount and you're pissed off. So they figured, how can we get these guys? So they went to the MLS that they all ran. They were all on the board because it was a matter of their creation back in the day. They changed the rules to say, hey, to be an MLS member, you got to have a physical presence in the market, got to offer the full array of services, all the stuff that the innovators weren't built to do. Innovators go away. They're not pesky and needlesome anymore. Commissions return to where they're supposed to be. And suddenly the old boys are able to take, split their 7% commissions again. FTC got them, no restitution. I came in and we sued in 3 markets, Detroit, Hilton Head, Charleston, and Pittsburgh. And we resolved all those and got people their money back. So you are absolutely right. Totally agree.
Perhaps this is a good time to turn to our last bucket of topics, which is raising awareness and perhaps education of consumers' legal rights. What would you say are the biggest what are the most important things that consumers perhaps don't know about their legal
I think
rights?
the important thing, of all of them, the consumers can have is awareness, legal awareness and empowerment of their rights. And I'm glad you mentioned that because this goes right to the new web brand that I created, my www.yourlovablelawyer.com, which is really intended to address the following problem. In 30 years, I've recognized that there is really a bias out there against access to justice. Excuse me, access to justice, where people who deserve it the most tend to get it the least. They don't know they have an issue. They have an issue, they don't know how to resolve it. If they know how to resolve it, they don't know who to turn to. If they find a lawyer, they don't know how to pay for him or her. All sorts of issues and concerns and problems that folks like us don't appreciate. Well, why? Because we're lawyers, or if we weren't, we'd probably know one. And a lot of times people just eat it. They just take it and don't realize that they have rights. Look at COVID. For instance, COVID waivers. Somebody shoves a COVID waiver under your nose and you're dropping your kid off at baseball practice. I don't know what I'm signing, but I know Johnny wants to get out of the car and he's making me crazy. What did I just sign away? What did I just give away? Did I do something bad? PPE issues. What need my workplace do to keep me safe? What are my rights and remedies if they don't? More evergreen issues like forced arbitration, like what to do if I'm in an auto accident, like what to do if I'm involved in a traffic stop. Just simple bases and buckets of legal awareness that people don't know to appreciate. And I want to bring that to folks. And it doesn't cost anything to subscribe. It's just a function of having a resource. And that resource was lacking. I'll finish with this. What really brought this idea together was I took a look at the daytime TV landscape. And, there's a lot of, call it physical and emotional wellness content out there like Dr. Oz and Dr. Phil about how to be safe and well in your mind and body. There's a lot of financial wellness content out there. Susie Orman, Jim Cramer, how to open a 529, an IRA. But there's nothing to fill that third essential bucket, doctor, lawyer, financial person. Nothing to fill that legal bucket, to give you legal wellness, except these trumped up, silly courtroom dramas that attack the problem after it's already blown up for dramatic and entertainment purposes, not curative, value added, ahead of the curve purposes that are really sustainable and worthwhile and necessary. So that's why I put this brand together and created all these videos and all this content to really offer an outlet and opportunity to have that legal aptitude. I don't say advice. It's not about advice. It's about awareness that they wouldn't otherwise get. So that, I think, is what's most essential to people out there.
Yeah.
And I was just going to say, and it's not just necessarily a waiver. It's also the noise that you get when you're asked to say, you buy a product and somebody says, okay, here are all the disclosures. Go to a website. Here are all the disclosures you have to make. Everybody just clicks yes to that, right? Because, and again,
Yep.
I don't really even know why I might have just agreed to that. Now, as I represent clients, I will never allow them to sign anything unless I fully understand everything that they're signing and everything they're giving away, and we're advising them on that. Mm-hmm. But I think people all the time in their personal lives are like, okay, I haven't really read this, but okay, and I don't really know what it means.
Well, look at the Uber driver case. All these poor Uber drivers click through the app to become Uber drivers, not realizing they clicked forced arbitration clauses. And now they're all banished to forced arbitration. And a friend of mine thought to gather about, 10,000 of them together and to file a swarm arbitration, which I just got out of doing. And it's a heck of a lot of work. And she's like, we'll give them what they demanded. And what did Uber do when it got hit with that swarm arbitration where they had to pay for these arbitrations, by the way, like $3,500, I think is what the AAA charges, times 10,000. They ran back to court and said that it's unfair. We'd rather be here. Can't exactly unring that bell, Uber. So, yeah, there's a lot of stuff baked into these wraparounds and click-throughs, and it's pretty dangerous stuff. People have to know that. I might do a video about that one, John.
Well,
I just have one. John. I just have one quick follow up, and it'll be the last substantive question coming from me. That would be: you mentioned COVID. Do you expect to see some COVID related class action coming your way or anyone's way?
Oh, geez. Do I expect? There is a list as long as my arm of COVID class cases in suit. The only COVID class case I have going is a business interruption claim where my client and friend who owns a furniture store had to close his doors, and he made a claim on his, CGL policy, would it be? And was told, we don't cover COVID. And you read it, and it sure sounds like you do, but we're fighting motions to dismiss. And actually got past 12B. I'm sorry, we're in discovery. Well, those are tough cases too. I mean, nothing's easy. If it were easy, everybody would do it. But they're higher education cases. There are workplace cases. I mean, they are everywhere. And some of them really stink. Some of them, though, are really good. So you have to be very careful. If you're on the plaintiff side, picking and choosing where you spend your time and money, or often someone else's money, in pursuit of justice.
Danny, all very interesting stuff. Let's shift gears a little bit. Let me ask you this question. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
I just came off yesterday 4 days at a fiction writers conference because I've been working for about 12 years. I hate to confess to how long it's been on my first novel. I do a lot of writing. A lot of my legal writing is, of course, and legal articles are nonfiction, although some would accuse them of being purely fiction, but they're nonfiction. And I wanted to pour myself into the fiction space. And I've been attending writers' conferences and reading writers' books and studying with authors for about the past 6 years of the 12, meaning the first 6 years of writing were garbage. And it's a completely new craft. And I teach legal writing, and I channel my legal writing curriculum through fiction writing themes for readability. And people are knocked out and don't really get it. But just like a novel, you want your judge, who's your sole audience, to keep turning the page and to be interested and not want to put it down at 11 o'clock when she's got an early motion call or he's got an early trial. And the novel is what I'm most dedicated to. I'm sending it to my editor probably day after tomorrow after I make some more changes. And we're going to hopefully spruce it up in such manner as to get it published, or get an agent, God willing, and get it published, double God willing. So that's kind of my biggest side hustle.
No, I don't want to spoil any surprises, but what type of novel is it? Is it a mystery?
Sure. It's about what happens to this young yet misdirected class action lawyer when she's forced to take down her powerful law firm and expose its blood-stained secret before its senior partner destroys her family. That's my through line, or some version of that. I'm forgetting it. And I wrote a woman. I'd written a man. It wasn't going anywhere. I had an author tell me, it's a little flat, change your hero to a woman. And I interviewed several female attorneys and learned really from the inside out what it really means to be a woman in this profession and to walk into the conference room full of, 12 white guys and feel something that I don't feel, or walk into a deposition and be mistaken for the court reporter. I mean, awful, grisly stuff, not in a, blood and gore way, but really painful stuff, and how she had to overcome those challenges and obstacles and concerns as she made her way to the top in a misguided way, which is what leads to our climax.
Interesting stuff. Okay, we'll look forward to that. Let us know when you're ready to option the podcast rights.
Again, I hope to have the chance. Yes.
Separately, what would you tell young lawyers that want to do what you do or be successful in the law? What advice would you give them?
I teach law school, and I routinely say to my students, who are they're interviewing, and they ask for advice, and I say, listen, let's flip the script. Let's say rather than my interviewing you, you're interviewing me, and you can ask me one question. But one question, the answer to which will largely affect whether you want to hire me. What would that one question be? And it's usually some version of, are you a hard worker? No. Why do you, tell me why you want to work here? No, that's not it. The question is, and again, there's no shame in this. The question is, how will you make me money? You can be passionate and committed, but by God, it's a business. How are you going to make me money? And I say to these students, how are you going to make your employer money? Well, you got to bring in business, don't you? Yeah, you do. Okay. Do you have a ton of business you can bring with you out of law school? No, I don't have that. Oh, okay, fine. Let's not go there. Oh, here's one. Is your family, do they own a Fortune 100 company where you could suddenly be general counsel or direct a lot of stuff your firm's way? How about that? Let's go with that. No, that doesn't work either. I said, oh, shoot. What are you going to do, man? Like, how are you going to add real value right out of the gate? Oh, I got one for you. How about you're the better writer, the better, brighter, tighter writer every single time? Because if you can write well, you're going to win stuff. And when you win stuff, your partner's client is thrilled. And when she's thrilled, she hires him again. And he wants you on the job. Or better yet, she steps over him and hires you. But you know what? Becoming the best writer you can be is accessible. It's really hard, but it's available to you. How do you do it? Read writing books. Read good writing. Write every day. Take a Brian Garner program, for crying out loud. I've studied with him for 25 years. Do any number of get daily writing emails and study writing every day, which I just did misplaced modifiers today. And it matters. You will become known as the writing person. People will want to work with you, and you will move right up in a way that your colleagues don't have the aptitude or sensibility to even think of. Do that. You'll be a winner.
It's funny because the answer that I would give is a little, I think we would align, but the answer I would give to that question is slightly different, which is do whatever you need to do to make the folks that you're supporting, make their lives easier. In a sense, it's to please, you do a great job. You do a great job on helping the clients so that I can think about, I'm at a different stage of my career. I can think about other things. I can think about going and visiting with the clients and things like that. And but I like your insight because it is really hard. Some of the things that I do that I have to do myself are really hard for a young lawyer to take off my plate. But giving me a super good first draft, that takes a lot off my plate.
Oh my God. It's refreshing, isn't it? Writers write terribly. They're some of the worst writers I've ever read. And you put a good piece of prose in front of a judge, it's illuminating. Through the ABA Class Action Institute, I've taught with scads of judges. I routinely ask them about writing, and they say, God, tell me the issue, make it clear, give me the answer. Don't make me hunt and peck. Please. I got enough to do.
And and you're right. And there's some things that we learn in law school that they take our brains and then they try to teach us to think like lawyers. And in doing that, you have to get back to being a good communicator and a good writer. You actually have to unlearn some stuff.
I had somebody today tell me, we're talking about promoting my web brand, and he said, I was describing the Class Action Institute as a revival, not a CLE. He said, you know what? I like the way you talk. I like the way you communicate. I like your syntax. I said, you like me because I don't talk like a lawyer, don't you? He's like, yeah, that's right. I get you. Be approachable, read and write in a way that people will understand. I have a few essays on writing and speaking that I've written for Law 360 that if anybody wants to take a look, you'll find them. They're accessible. They're easy to understand and read and enjoyable. And I'm hoping they'll make a big difference because they matter. And somebody once told me, you're giving all these writing secrets away, these speaking secrets away. Aren't you concerned about giving up the keys to the castle? And I said, I'll tell you what someone once told me, which is, never mind sharing your ideas. For if they're truly revolutionary, you'll have to cram them down people's throats. So I've not had that problem yet.
Interesting stuff. Let's go to our final segment that we call The Curious Hat.
And now it's time for the Curious Hat.
So what I have is a list of questions, and they are numbered from 1 to 25. So what I'd like you to do is choose a number, and I will read the question that corresponds with that number.
All right. My birthday is April 11th. I will go with 11.
Okay, question number 11. This is actually one of my favorite.
Okay.
What is your favorite Disney character?
Disney character?
Disney character.
Disney character. I'm thinking old school. That's the first thing. Boy, I don't know that he's favorite, but Pluto comes to mind. And I think it might be a function of my now having 2 dogs. And if my wife listens to this, she'll say, I knew you're going to come around. So, you can't claim privilege on a podcast, but I'm going to go with Pluto. And that's the reason why.
So it's interesting because there are other ways you could go with Disney dogs. I mean, Goofy comes to mind. Are you saying you want more of a realistic experience from your cartoon dog?
Say again?
Are you looking for Pluto? I think is a more realistic experience in a cartoon dog.
Yeah.
Goofy's a talking dog. Is that what you're looking for? More of a realistic experience.
Well, Pluto doesn't talk, right?
I think so.
Notice I'm using present tense as if they're still making Pluto cartoons. But so mine doesn't talk, and Pluto's kind of golden brown, and mine's a golden kind of brown lab, and she's got to be 100 years old like Pluto is. So yeah, I'm seeing some maybe subconscious parallels there that are, make me gravitate toward Pluto.
Interesting. Okay, and just a follow-up question. Do you have a favorite fictional superhero?
Fictional superhero. I was big into superheroes. Spider-Man was my biggest one. I collected mostly Spider-Man. Really dug Spider-Man. The more I watched the new kind of remakes of Spider-Man with the new Spider-Men, the more hackneyed they become. But that doesn't tarnish my lifelong, appreciation of them.
What is it about Spider-Man that draws you?
I think it's probably I got into him when I was in high school. Might have had to do with that high school thing. So there's that. An ordinary person doing extraordinary things, which I didn't appreciate until I started fiction writing, which is what fictionalized characters ought to be about. So for instance, see how self-serving I am? I'm getting back into my book. It's about this Sabrina James, our protagonist, who just wants to do a good job, and she's thrown into stuff, that insane stuff to her boss that you'd love to say, but you never would in real life. I think there's some elements of that affected me that I didn't appreciate. I couldn't put the proper kind of veneer on them until I learned the elements of thrill writing. Yeah, which is really what superhero genre is.
And I'm not neither a fiction writer nor a copyright lawyer. But if you were to have your hero bitten by a radioactive spider, you might have a problem.
Oh, maybe. See, you know what? I thought I was switching the hero from a man to a woman. Maybe I should have had him get bit by a spider. Now that puts it in a different place. Yeah, the sequel. That'll be the sequel.
All right, well, give that some thought. And when you're ready, come back to us for the podcast rights. But until then, we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust.